Rule 612 can be seen as the court's emergency door. And you don't just get to go through that door because you've missed your flight. Rule 612A seeks the court to condone the non-compliance with the rules, the normal rules, contained in Rule 6 relating to procedures for setting down of matters. You have to justify a reason for a deviation from those rules and seek the condemnation of the court in that regard. Rule 612B requires that in your affidavit you need to set forth explicitly, and that means very clearly, the reasons why the matter is so urgent that your client cannot receive substantial redress at a hearing in due course. So the stakes are high. It's not just there for the taking. Now, I've had the privilege and the benefit of both presiding over urgent applications and, of course, drafting urgent applications. I've frequently heard the following, which tends to amuse me. It says, but we're a creature of instructions from our clients. And my retort to that is, yes, you may be a creature of instructions from your client, but you are a creature with a brain and a law degree, and your task is to advise your client as to the correct procedure and whether or not the matter is sufficiently urgent for you to approach the court by way of urgency. Now, let me put to you that the various divisions have practice directives which inform certain procedures relating to urgent applications in that division. I'm not going to go into them, and you're well advised to research those yourself. But regardless of those practice directions, it does not detract from the content of the rule. Rule 612 applies regardless. Now, a tip. I have drafted a number of urgent applications. In fact, last week, I had 2 urgent applications being drafted almost simultaneously, with plenty cups of tea and plenty chaos going on. But you as a practitioner need to, at the outset, ask yourself, is this matter really urgent? And you better ask yourself that question, because the judge is definitely going to ask that question. We have something that we call self-created urgency. You cannot come to court just because you missed the boat or your client delayed to the last 11th hour, and they suddenly want the court to come to their assistance. Because one of the questions that's going to be asked is, when did this problem arise? And if you come and say, 2 months ago, well, you're going to be very hard pressed to convince a court that this matter is urgent. Because what would you have been doing, or your client have been doing, in the last 2 months to suddenly come and want to slip in to the emergency door? You're going to have to have a very good explanation. So that's going to be the first question. When did it arise? Right, let's assume that it arose right now. What makes it so urgent that your client cannot use the normal procedure? What makes it so urgent? And that's a question you're going to have to ask yourself, because again, the judge is going to ask that question. What makes this so urgent that you cannot go with the normal procedure? So ask your client, make a value judgment on that. And then there are levels of urgency. It's not unheard of that an urgent application can be in court within an hour, depending on the urgency. If it's a matter of life and death, you'll get in that emergency door very quickly and the judge will hear your application. But if you're bringing an application because your client forgot to do something which should have been done a week ago, or whatever the case might be, and now all of a sudden you and your client are deciding to plead for the good graces of the judge to allow you to slip your matter in, jump the queue in front of everybody else, and have your matter decided urgently. From experience, the chances are it's going to be a no. A no. Your job is to evaluate what you have before you, to make a decision, to communicate that decision to your client, and to draft your application accordingly. Because at the end of the day, it's you that are going to have to account for why the matter was deemed not sufficiently urgent. If you enroll a matter and the court finds that it's not urgent, it will be struck from the roll with costs. So you would have cost your client money. Then of course you can enroll it in a normal course, which is what you should have done right from the outset. So you would have cost money to your client, and you would have been forced to do it in the normal way in any event. So, my advice to you is this. Do not think that the urgent application is there for the taking. You need to prove that it is justifiable to relax the normal rules and procedures of court. You have to explain what renders this so urgent that you can slip in front of other people. And it's not just, this is urgent, you need to give explicit reasons. And you need to explain why you cannot get relief at a hearing in due course. Please think clearly before you rush off to court with something that is supposedly urgent. It's been such a pleasure to share this pause with you today. Remember, your voice matters. So don't forget to like, subscribe, and tap the bell for the next tea adjournment.